It is a pleasure to introduce you to Justice P. Scott Neville. How are you? Junior.
Very good. Thank you for having me on your show.
First of all, thank you. You're a sitting judge right now?
I'm a sitting judge. I've been a judge for 12 years. I sat on the Circuit Court of Cook County for 4 years, and I've been on the Illinois Appellate Court for 7 years.
Oh, so you're presently on the Appellate Court?
I'm presently on the Appellate Court.
Yeah, see, I tell you people that I like to learn as I go, and I've never even looked at his biography. He got recommended by the right people to get on the show, so if you know somebody you want to recommend, recommend them. I'll be happy to put them on. So you were elected to the Appellate Court?
No, I was elected to the Circuit Court. I'm seeking election to the Appellate Court.
Gotcha. And right now you're sitting in, explain to us about the Appellate Court.
Okay, I sit on the Appellate Court. As you may or may not know, the Appellate Court reviews decisions from the Circuit Court. That is, it doesn't make any difference if it's a criminal decision or a civil decision. We review that decision. In fact, ladies and gentlemen, the Appellate Court is the court of last resort. 95% of all appeals go no further than the Illinois Appellate Court. The Supreme Court has discretionary jurisdiction, so they're not required to hear every case. The Illinois Appellate Court is required to hear every appeal from a final order, and there's some rules that apply to interlocutory orders. So we are, in fact, the court of last resort.
Now, how does that? Now, do you sit yourself, or are you with a panel, or?
Well, I'm glad that you asked that question. The Appellate Court in Cook County has 24 judges. We sit in 6 divisions. We sit in divisions of 4. It takes 3 judges on each case that we hear, and it takes 2 judges to concur in that decision in order to have a majority opinion. So you've got to get 2 people to agree. Of course, if the third person doesn't agree, that person would dissent. But you must have 2 people agree, 2 of the justices must agree in order for us to rule or make a decision.
And where does the Appellate Court meet?
Well, we sit at 160 North LaSalle.
Right, that's a better word, or sit or convene, or rather
Right.
than what, yeah.
Right, we sit at 160 North LaSalle in the old State of Illinois building.
Ah, okay, not the Thompson Center.
Not the Thompson Center. No, we're across the street from the Thompson Center. They have rehabbed or refurbished the old State of Illinois building, and that's where we sit. We occupy half of that building.
Now, how long does an average case take?
Well, I guess you're asking how long does it take us to dispose of a case, and that's a very interesting question. I would say it depends on the justice hearing the case, but I would say I dispose of most of my cases within 60 to 90 days after they are ready to be heard. Now, the Appellate Court has a little rule. After the Appellee's brief is filed, that case is considered ready and it is assigned to a judge for disposition. After I get those cases, from 60 to 90 days we dispose of them. It's probably more like 60 days.
That's actually pretty good, it sounds like to me, compared to the general system.
Well, let me just explain something now.
Sure.
Remember, those cases have come up on appeal. They've already been tried. A judge has already reviewed them. And all we were doing is reviewing the decision that has been made by the trial court, in fairness to what goes on at the trial court, where discovery has to take place, and there are a lot of things that have to go on in order for that case to be made ready for trial. Now, the one thing that takes a case a short period of time to get to the appellate court is the time that it takes to prepare the record. Then the lawyers have to write the briefs, and then they have to file them. And then once, as I indicated, the appellee's brief is filed, then that case is assigned to a judge for disposition. And we are getting some concerns are being expressed by the lawyers who are members of the Appellate Lawyers Association because we don't hear a number of cases. Now, here's where we have to balance the interest. If I set a case for oral argument, that case has to be set 4 weeks before, that is, my secretary will notify the law bulletin, the lawyers get notice 4 weeks before it's set for the actual argument. Then it takes at least 2 to 4 weeks for us to make a decision. So if you add on that additional 6 to 8 weeks, that's more time than it would take me to dispose of a case. If I eliminate those 6 to 8 weeks, I can make a decision in a shorter period of time, and I should amend that statement. I'm not making the decision alone, but I have an opportunity to write an opinion or a Rule 23 to circulate it to the other two judges who have been assigned to the case. And then once they have expressed their opinions, either concurring or disagreeing, but once I have a second concurrence, then that case is filed and it's disposed of.
What is Rule 23?
A Rule 23 is it's a decision that is not published. An opinion is a published decision,
Yeah.
and it has precedential value. A Rule 23 has no precedential value, which means it cannot be cited by a lawyer as authority for their position in a particular case.
Gotcha. Why don't you tell us something about your background?
Well, I grew up in the city of Chicago. I've always lived on the South Side. I always like to tell people, like Harold Washington, I went to Forestville Elementary School and DuSable High School. I went to Culver Stockton College, and I'm a graduate of Washington University School of Law in St. Louis, Missouri. However, immediately upon graduating from Washington University, because I've always considered Chicago to be a world-class city, I immediately came back to Chicago, where I began the practice of law. In fact, I was the first African-American man to ever clerk for an appellate court justice in Cook County.
Wow.
And that was in 1974. I've been practicing law for over 37 years. After concluding that clerkship, I had an opportunity to participate in over 55, I think, appeals. 25 or 26 of the cases that I filed in the Illinois Appellate Court are published opinions. I'm aware of this information because I just made a presentation to the Appellate Lawyers Association. So I have a great deal of appellate experience, probably more experience than a lot of the people that sit there. And since I had clerked before I practiced law, I was very familiar with what went on in the Illinois Appellate Court. In fact, I clerked with the man who's presently the clerk of the Illinois Appellate Court, Steve Raven.
Wow.
We clerked together.
Very cool. So yeah, you basically cut your teeth on the appellate court.
There's no question about it. I always like to say, as a friend of mine once said, that I got a view from the top.
Yeah.
And it always helped me when I was practicing law, because I had a very good sense as to what judges were thinking and how they look at cases, and I prepared my cases accordingly.
No, that sounds real good. How are you finding campaigning?
Well, let me just say this. As one of my mentors, Justice Pincham, said, like life, it's a rough, rocky road, but you have to travel it. And I'm personally for the election of judges, so I don't mind the process. I think it's a good idea for judges to get out and meet people and to find out what they're thinking. Now, of course, I also like to remind people that I strictly adhere to the law. I sit on an intermediate appellate court. I'm bound by the decisions that are made by the Illinois Supreme Court and the U.S. Supreme Court. So I simply follow those decisions, and I strictly construe the statutes that I review.
Very good. If people would like to contact you?
They can contact me at pscottneville.com, www.pscottneville.com. They will go to my website, and they can certainly contact me through my website.
That sounds great. I want to thank you very much, Justice P. Scott Neville, Jr. And thank you so much for being here, and good luck in the election.
Well, thank you very much for having me.
Thank you.